Due Process, recipient of 5 Mid-Atlantic Emmy Awards since 1997.
There's definitely a problem with people living together not being married. There seems to be a problem with that.
She gained a live-in lover and lost her temporary alimony. Is it fair? Is it law? And have our laws kept up with the way we now live? Cohabitation and the law? It's what's on the docket for this week's Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
Marriage rates are at an all-time low, and so is the stigma on those who live together without the wedding. I'm Raymond Brown, and clearly more and more of us are choosing live-in partnerships outside of marriage. But has our legal system kept pace with our new social realities? Full marital rights for non-married couples, marriage as an option for gays? Or should traditional marriage between man and woman retain its special rights and privileges? We'll be looking at those questions and more. But first, here's Sandy King with a story of how having a live-in partner changed the financial picture for one Morris County woman.
Raymond, this is a story of marriage and divorce, of cohabitation and an out-of-wedlock child. And at the crux of this story, money. What the courts call temporary rehabilitative alimony. And a woman who lost it because a man moved in. Now, you may think that just makes sense, but till now, there was no such legal provision. Did the judge go further than the law provides? Did he change the rules as a moral judgment? And is Beatrice Romay paying the price for her less conventional kind of family?
Just Molly and me, and baby make three. We have in mind, please,
Did you give me a smile? Now you remember, right?
She has the baby and the man, but what she doesn't have is the marriage license.
That's it. Hello.
So Beatrice Romay wants to know why a Morris County divorce court has treated her as remarried.
To punish me because I'm moving on with my life, I can't put my life on hold for 5 years until Mr. Romay is ready to settle on his terms and give me a divorce on his terms.
What they're trying to say is that once you're separated and you move on with your life, you're not entitled to have a steady relationship.
But it's not the relationship to which Judge Herbert Friend said she is not entitled. According to his November order, Romay's live-in romance means that the CPA husband, from whom she's not yet divorced, is now off the hook for the interim support he had been ordered to pay.
I don't think she's being punished whatsoever. As a matter of fact, she took it upon herself to enter a new relationship and to have a child with her acquaintance. And that, to me, is tantamount to marriage.
But under New Jersey law, just living together does not amount to marriage, nor does it carry the rights and privileges of marriage.
Still in the state of New Jersey, they still can't collect health benefits. They still, unless their deed on a house they buy specifically reads, joint tenants, there could be difficulty if one partner passes. Unfortunately, we live in a society still that does not recognize relationships unless there's a marriage, unless there's been some type of approval by the state as well as the church.
And until now, cohabitation was not grounds for cutting off temporary rehabilitative alimony. There was an earlier case last year in which the state Supreme Court said support should stop if a no cohabitation clause had been included in the divorce agreement.
The Supreme Court has said we're going to attach a lot of significance to that agreement.
But here there was not only not such a clause, but there was no agreement.
That's correct. So I have to believe that it was the conduct of the parties.
Conduct that may still raise eyebrows in a society that places special value on formal marriage.
Unless you're married, you really don't have any rights. You don't have any rights as a married couple would.
And when it came to alimony until now, living together had only been important as it impacted on financial need.
The judge focused on the conduct of the parties and not on the economic consequences of terminating alimony.
The fact that she was living with another man.
I believe so.
In his opinion, Judge Friend declared, where the plaintiff has entered into a new marriage-like relationship, the court need not delve into the economic needs of the wife. If he had, says Beatrice Romay, he'd have found that though she's working full-time as a merchandising analyst, her years of being in the marriage and out of the mainstream job market have slashed her earning power. He'd have also found, she says, that Gerald Ramjatan, her live-in partner, is a forklift operator who makes very little money.
He was able to help me out maybe 20% with what Mr. Romay's obligation was at that time.
You thought that was fair?
Yeah, I mean, I even me and my lawyer, we suggested that we would be willing to reduce the amount, the support obligation, according to as what he's able to help me out with.
But the court was applying a different kind of standard.
She chose to get involved with another man, live with the man, admittedly in a relationship tantamount to remarriage, and have that man's child. So I don't think she's being punished at all. I think she went into it with open eyes and knew or should have known what the consequences would be.
In fact, a ruling for Beatrice Romay, the judge said, would discourage the institution of marriage.
Whether it's a moral judgment or not, I don't think so. I think it's a factual judgment.
The result, the order that she'd pay back thousands that she'd already received and pay another $5,000 toward her husband's legal fees. That despite what her lawyer says about the facts of her case.
This marriage destroyed Mrs. Romay's ability to earn a living. She was making $50,000 when they were living together, and then she gave that up because with his encouragement she gave that up. And now she doesn't have that ability anymore. It's been 8 years.
You need to address that people choose lifestyles and that we need to respect those lifestyles, whether it's recognizing a traditional marriage, whether it's a same-sex marriage.
And Joseph Romay's lawyer says Judge Friend's decision is just keeping up with that new social reality.
Now people are living together under all kinds of circumstances, and I think that the law has to be changing, taking into account social mores.
So was the judge keeping up with new times, or was he passing down an old moral judgment? And if living together amounts to marriage when it comes to cutting off alimony, what about insurance and income tax, inheritance, and the rest? Now, the argument is if you want those rights, get married. But, Raymond, what if you're gay and marriage is no option?
Sandy, those are just a few of the questions we'll be asking when we come back with a panel that's poised to fight it out. There could be fireworks, so stay with us.
Well, I don't think it's right because I think it's against the Bible.
If they're serious and it's a long-term relationship, I think they should be treated like married people. But without documentation, it's very hard to find out.
Some people live together for 10, 20 years, even die together, and they can't get the benefits.
It is a disgrace. Everyone living together should be married. It's right before God.
Married, unmarried, doesn't make a difference. Taxes and everything should be the same for everyone.
Every person should be able to have insured themselves and one significant other person.
That's another form of stereotype, I believe. You know, I think that everybody should be treated equally.
People get married because they're in love. People live together because they're in love.
They should be allowed to do what they want. Life's too short.
And still, marriage holds a legal place all its own. But there have been some changes. Some colleges, some businesses now extend benefits to partners. The Vermont Supreme Court has even ruled that the state must guarantee the same rights and protections to gay couples as to heterosexual spouses. So where are we headed? What's the right way to go? For some answers, we'll turn to Mark Beal, chair of the State Bar's Family Law Section, to John Timicki, executive director of the American League of Families, and from Newark, Marilyn Sneerson, an advocate for full legal recognition of gay partnerships. Welcome to all of you.
Thank you.
Mark, let me start with the legal principle, although we want to get beyond divorce and matrimony. I do want to talk about what would normally have happened before Judge Friend's ruling anyway. In a case like the one we've looked at, wouldn't the judge have held a hearing to find out what the impact on this lady had been of her living with someone?
Absolutely, Ray. For 30, 40 years in New Jersey, the law respecting cohabitation and its impact upon support has always been an economic needs, economic benefits test. As a result of cohabitation, was there the ability to reduce the support because you were getting something from your new relationship, and what should that be? And the court this last year, the Supreme Court in Consulman, while they upheld an agreement, and I emphasize the word agreement, where there was a 120-day provision that if you cohabited, alimony would be terminated, and they determined that if the agreement was fair and equitable and entered into without duress and with legal counsel, there would be a basis to terminate the alimony. What Judge Friend did was simply extend that and really, if you ask me, disregard the clear dictates of the court.
So if he went beyond the law, let's look a little bit at his motivation to the extent that we can figure out what it is. Was he saying, in a sense, that you should be punished for cohabiting, or was he elevating cohabiting to the same status of marriage? I mean, you could look at it both ways. Which way would you look at it?
Well, I look at it that it was really a punitive measure. It was a punitive measure because there wasn't even a hearing offered to begin to evaluate step one in a relationship. There came a time where Judge Friend said, I'm going to order some temporary rehabilitative alimony. We in the law are not sure exactly what that concept means.
Let me stop you for just a second. When you use the word punitive, then, why was he punishing her? What was the basis of the punishment? Because she was living with somebody?
Well, I think so. I think that he found it morally offensive that not only was she living with somebody, but there was a child involved, and apparently they were living in a marriage-like setting. And I don't think that there's any question that that is the case. But this is the first case where alimony without a hearing was ever terminated on that basis.
John, if Mark is right in his analysis that in fact the judge was essentially punishing a person for cohabiting and having a child outside of marriage, what's your view about whether that's good justice or not?
I go back to the basic issue right up front.
Okay.
We've always believed that if there is marital misconduct and there's an innocent and injured spouse, I want to go, you're all into the little stitching around the edge of the problem.
You can go to the heart of it.
Go right to the heart of the problem. In the first marriage, which there was only one marriage, because I don't know all the fact pattern here, but we should go in, shouldn't a spouse be able, should a spouse be able to raise marital misconduct if they themselves are an innocent and injured spouse? As to any issue, divorce, whether they should be divorced, custody,
John,
alimony.
Let me pose it to you this way.
So I'm coming at, where was that initial marital situation?
Let me see if I can focus you for a second. Let's assume that people are separated and in the process of undergoing divorce, and one of the separated persons moves in with someone else. Mm-hmm. Do you think that that person should be punished by having, on that basis alone, alimony and support withdrawal?
Are there any children?
Let's assume there's a child of that new union.
A child of the new union?
No child before, but a child of this new relationship.
Then the father of that child of the new union has a responsibility to take care of that child.
Well, let me come back. You've always been pretty direct. Let me come back to the issue. Do you think the person should be punished because they're living with someone else?
You used the word punishment.
That was Mark's word.
Well, you're saying Mark's word. You're in here too. You have your own opinion.
No, I'm asking you to respond to what Mark said.
The issue is, nobody should be sitting there in punishment. I don't like the word punishment. I don't know what was on the judge's mind. I think you put it right. Which way was the judge going? Was he elevating the cohabitate? I don't know what he was doing yet. I'm sure it's going to be reviewed on appeal to go back whether should he have had a hearing or not. If that one spouse has now said, I am terminating the relationship and I'm moving into another relationship, well, in the old days, 20, 30, 40 years ago, at least now we're cohabiting, that's adultery. So the spouse, who is the innocent and injured spouse, says, I no longer have any financial responsibility to take care of that person.
If you're talking innocent and injured, then we are talking some moral judgments. And let me bring Marilyn in, because the question I want to pose is, beyond just this case.
We always want to protect the innocent and injured spouse. We always want to protect the children of a marriage.
But the question here is, Marilyn, whether or not there are moral judgments that are coming into the legal arena that do or don't reflect the way in which society is moving. That is, if more and more people are cohabiting, and all the numbers we see, a recent study by the University of Michigan suggests now that maybe 90% of people who are married now or have married in the last decade cohabited before they got married. That's a change from the past. Is that a change that ought to be reflected in judgments in the courts and the actions of legislators?
I don't think that our courts should be the moral police of what today's relationships consist of. In our situation, I represent a man who had a 14-year committed relationship with another man. For all purposes, they were a married couple, but for the fact that in New Jersey they could not obtain a marriage license and they could not go through a legal ceremony. I don't think that our courts today are going to impose their moral judgments on whether that 14-year committed relationship between two men is improper. The issue is, was it a committed relationship? Were the people acting for all purposes as a married couple?
But Marilyn, if we contrast what, for example, the Vermont Supreme Court did in saying, look, we're essentially going to treat all committed relationships alike and insist that the legislature find a way, doesn't that seem to be contrasting with what Judge Friend seemed to be suggesting, that there was a judgment that to be made on a cohabiting relationship?
I'm not sure what Judge Friend concluded. I don't know the facts in that case, but it seems that Judge Friend was applying the current state of the law for heterosexual relationships. If for all purposes, a man and a woman agree and go forward with a relationship that, but for the fact that they did not go through a legal ceremony, other than that, they act as man and wife. They are, for purposes of the whole world, man and wife, then the financial obligations are between that man and that woman.
John, let me ask you the question as broadly as I can. In your view, should a position, for example, like that of the Vermont Supreme Court, that all committed relationships, regardless of whether inside marriage or out, whether heterosexual or homosexual, should be entitled to the same protections under the law, is that something you're comfortable with or not?
No, they should not be given the same protection. Our position always has been based upon 5,000 to 7,000 years of history, which comes out of most of the work done at Harvard by Pitriam Sorokin. He talks about when you loosen the sexual mores of a society, when it no longer has that premier protected status of the traditional marriage, the traditional one man, one woman marriage, it is the precursor of the demise of that particular civilization. Now, I don't think we're going to see the end of the United States of America like coming next week. But you keep talking in terms of how the number of cohabitation has risen. Well, we call it the broken window pane syndrome. There is a moral decline in this country that everybody agrees to. I also would like to challenge that law serves as a teacher. Law also works as a moral guideline. And unfortunately, most lawyers are not trained in the old Blackstone way, which understood English common law, and all law reflects some moral law. Which law are we reflecting here? And cohabiting, domestic partnership benefits, gay marriages. Gay marriages is a ideological oxymoron. It doesn't exist. That's another whole subject matter.
Mark, let me ask you this question. If, in fact, John is articulating a view about how things are, but that view is in marked contrast with the way people live. People do cohabit. There is a broader acceptance generally, and maybe more instances of gay relationships that look like marriage, except that they don't have the blessing of the law. How do you reconcile those two competing forces?
Well, in the first place, you have to reflect on what the courts and what our legislature has said about the issue of fault. And the bottom line is, for the last 20 or 30 years in the state of New Jersey, the fault factor, per se, plays very little part in the economic issues, the underpinning of economic issues in a divorce scenario, whether it's in the element of alimony or equitable distribution. And if you really carry what Judge Friend has done here to its extreme, you could have the anomalous situation of someone married to a relatively wealthy, in the classic sense, man for many years, and he has done his job. He has gone out and worked hard to support himself, his wife, his family. She has done her job. She has stayed at home with the children, perhaps given up a career and other opportunities. And now in a 20 or 25-year scenario, which classically would be with a big disparity of income, a permanent alimony case, if this woman decides in terms of her divorce while it's ongoing or shortly thereafter to engage in a cohabitation relationship and doesn't elect to marry, as 4.5 million heterosexual couples in this country have so elected, then she would be cut out from alimony, notwithstanding this 20 or 25-year marital partnership. That's unconscionable.
Right, let me bring Marilyn in. Marilyn, let me ask you this. Do you see any likelihood that in New Jersey there will be a broad extending to all couples, cohabiting or married, heterosexual or homosexual alike, an identical set of protections throughout the law?
Yes, I do see that, and I think that in New Jersey, we all saw that very recently, where the adoption laws were extended to a same-sex couple. I think that what Vermont has recently done in their Supreme Court, I think New Jersey is going to follow. New Jersey has always had a very forward-thinking, rational view of marriage and of support situations, and I think that our courts will be not distinguishing whether or not a couple goes through a ceremony or not. In the case of gay couples, they cannot go through ceremonies in New Jersey. I think that the court will permit, however, a gay couple whose relationship breaks up the same kind of rights as a couple that has gone through a ceremony in terms of alimony. We can call it palimony, we can call it whatever we want, but I think that our courts are ready to rule in that way.
Mark, I see you shaking your head up and down. I want to quickly find out whether you're agreeing with Marilyn's prediction of where she thinks we're going.
Well, I do. The case law here makes this a very tough palimony state. It's very, very difficult to get a reasonable palimony award, if any. I do think that that's where the law ought to go.
John, A, do you have an agreement as to whether you sense that's the way we're going? And B, what's your view about where we should go there?
I notice the way we're going. Notice we right away went to the courts, where the courts are now setting the law. That's not where it is. Part of the grief that some of us have, which, for instance, with the New Jersey Bar Association, is that, number one, you supported legislation that was going to allow divorce just after 90 days. No question of fault, no question of whether we're going to protect the innocent injured spouse. You went ahead and said that parents shouldn't be involved in this notification issue on abortion. It was unconstitutional. So that I believe that the Bar Association, to me, is not having a good record of protecting the traditional family. So that within the legislative process, as the legislator speaks from the people, not where the court, as Janie Lavecchia said in her testimony when she said, I want to be one of your Supreme Court justices, I'm going to fill in the gaps for you people in the legislature. Quite to the contrary. Case law in New Jersey now says, it's an old case, it's more than 20 years old, marriage is one man, one woman. There is a state Marriage Protection Act working its way through the legislature where we'll define marriage. Just we're dealing with the marriages and not domestic partnership benefits. I see the law going the other way.
So you look to the legislature as a bastion. We're running out of time, Mark, but I know you want to say something on behalf of the Bar Association, which has obviously been painted as a source of undermining important values.
Well, you know, John points out that we opposed what really is called the irreconcilable differences statute, or that we supported the irreconcilable differences statute. We did because it's an antidote to a charade. People have to wait 18 months from date of separation till they can file a complaint for divorce.
So you say you're recognizing reality, not creating it.
Absolutely.
John, you think the legislature is going to win this battle in the long run?
Oh, I hope the people will win it and get more involved with what's happening in the legislative processes and not allow judges to just dictate.
And by winning, you mean they will put the brake on this movement towards identifying all couples inside and outside of marriage, heterosexual and homosexual, as having equal rights?
I see all kinds of surveys where people say, for instance, 70% Washington Post survey said they oppose same-sex marriage. That's one issue. Rather, we should protecting the innocent injured spouse. A whole women's movement has arisen to the fact that, you know, the 50-year-old husband is dumping the 48-year wife for the 20-year-old secretary in the office, and they're saying, wait a minute. I had certain rights. I sacrificed for the family. I'm innocent and I'm injured. And I'm talking about an innocent and injured spouse, and it could be the husband and a wife. That person
is
looking for protection.
What was the last thing you'd want to say to this court, if you had only 10 seconds?
Which court?
Our Supreme Court.
Oh, I ask some of them to resign, and I would ask other of them to pray for God's forgiveness.
On an interesting note, we end. Thank you, John, Mark, Marilyn. That's it for this edition of Due Process. But we'll be back next week with another issue of law and social justice. Till then, for Sandy King and all of us here, I'm Raymond Brown.
If you're just living together, you don't have the same rights, God forbid, if you get sick. If you get sick, they're going to call in your mother, your father, they're going to call in your next of kin, and they're not going to recognize your next of kin being your partner. Hopefully, most people, if they are in a relationship where they have a partnership, they'll prepare a living will. They'll prepare a health care proxy that will enable their partner to make those important decisions.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,